Hey, greetings. Welcome back once again to Categorical Imperatives. As always, I am your host, Lockie and Liberal. Thank you for joining me here today. For those of you who are new, welcome. This is a podcast where we will be using legal and moral philosophy to discuss current events as they relate to various aspects of politics and culture. And today, we are going to be doing the conclusion of what is turning out to be a three-part series covering a Washington Post article entitled What the Second Amendment Really Meant to the Founders. This is the article we are talking about here. And uh, what I've been doing is I've been using this article to demonstrate how our disagreements over the meaning of the Constitution, and specifically in this case, using the Second Amendment as the example case, are not, as most people tend to assume, differences of opinion that come as a result of different political affiliations. This really is not an issue of Democrat and Republican or liberal and conservative. It's really a matter of constitutional interpretation, and specifically of the methods of interpretation that are known as original intent and original meaning. If you have not yet watched part one and two of this series, I would strongly advise you to go back and check those out and watch this in proper order. So, down in the description, I will have links to those videos. Uh, yeah, I suggest you go check them out if you haven't yet. Everything will make a lot more sense that way. But uh, let's just take a quick refresher here. When we talk about original intent and original meaning, what are we talking about? So, original intent is the method of interpretation that maintains that in interpreting a text, a court should determine what the authors of the text were trying to achieve and to give effect to what they intended the statute to accomplish, the actual text of the legislation notwithstanding. And as in other means of interpretation, such as purposivism, tools such as legislative history are often used. And original meaning, which is also commonly known as original public meaning, is defined as how a reasonably intelligent and involved member of the public would have interpreted a provision at the time it was drafted. Primary evidence of original meaning is how words were used in common discourse, and based on definitions that we can find from contemporaneous dictionaries, legal sources, treatises, jurists, people like that. And where this comes into play with the Second Amendment is that the uh, the theory that the Second Amendment is a collective right of state militias is uh, is a view of it that is reached using original intent as a matter of interpreting the Second Amendment, whereas the view that the Second Amendment is an individual right to keep and bear arms for self-defense, not necessarily connected to militia service, is something that comes out of interpretation through original public meaning. Now, the purpose of this video here, the part three one, is we are going to be going through his remaining arguments. There's two more sections to his article, and he at this point he's actually really entirely giving up on actually talking about what the title of the article is meant to be, what the Second Amendment meant to the founders. He is, uh, well, you'll see. But anyways, at this point, uh, unfortunately, the argument that he has made in the first two videos about what the evidence is for original intent and the collective rights theory, you have heard as good an argument from him as you are going to get on that subject matter. I guess on the other hand, too, I think I've done a fairly good job of faithfully explaining and laying out the case for the individual right based on an interpretation of original meaning. But we're going to go through the rest of the article here because I think what he has to say is demonstrative of many historical and logical fallacies that play a role in how existing bias can distort our view of something like law before we even begin trying to interpret the law. I also want to point out how he, entirely by accident, as you will see, makes several incredibly important and actually really very true, deep statements that I don't even think he understands he made. So that's going to be kind of interesting. Basically, we're going to go through this together. I want to show you where he gets it right. I want to show you where he gets it wrong. And then before we wrap up at the end, I want to take a few minutes and talk to you guys about something that is known as textualism. That is another means of constitutional and statutory interpretation. And I want to talk about that because that is the mode of interpretation that I generally tend to follow. Uh, and so I would just be remiss if if I didn't take a few minutes here at some point to try and explain what that is and why I personally choose that method of constitutional interpretation. So kind of as we get to the end, I'll wrap it up, and I'm gonna just touch on that a little bit. But first, let's finish off with what he has to say. So yeah, he has two more sections in his article, and I'm going to just read these back to back because really these can both be lumped into one category with the general header that the Second Amendment is bad because racism. So, all right. So, point four here. The founding fathers were concerned about who should or should not be armed. The restrictions on militia membership that are critically important to understand because, despite the words of the Second Amendment, 18th century laws did infringe on Americans' right to bear arms. Laws rarely allowed free blacks to have weapons. It was even rarer for African Americans in slavery to be allowed them. In slave states, militias inspected slave quarters and confiscated the weapons they found. There were also laws against selling firearms to Native Americans, although these were more ambiguous. These restrictions were no mere footnote in the gun politics of the 18th century America. White Americans were armed so they could maintain their control over non whites. Non whites were disarmed so that they could not pose a threat to white control of American society. The restrictions underscore a key point about militias. They were more effective as a domestic police force than they were on the battlefield against enemy nations, and they were most effective when they were policing the African American populations. And point five, 18th century Americans tolerated a certain amount of violence and instability as long as it came from other white Americans. During the 18th century, insurrectionary groups such as the Carolina Regulators and vigilantes such as Pennsylvania's Paxton Boys showed that the colonial governments could not simply issue laws and count on the people to obey them, as did, one might add, the American Revolution, Shays' Rebellion in 1787, and the Whiskey Rebellion in 1791 showed that these problems would not go away with the arrival of the new republic, including all citizens in the militia and relying on that militia to enforce the laws that meant that issues which divided the citizenry also divided the militia. When disagreements over political issues turned violent, the government could not necessarily enjoy the balance of power over citizens who, as militia members, were trained and armed. These events also showed a pattern that emerged during the 18th century that Americans were willing to tolerate a significant degree of instability and violence on the part of white Americans. The Paxton Boys, for instance, murdered 20 Conestoga, I think it's Conestoga, excuse me if I'm not pronouncing that right, Conestoga Indians who had been living peacefully with their Pennsylvania neighbors for some time. And though the governor issued warrants for their arrest, and though Benjamin Franklin called the killers a disgrace of their country, no Paxton Boys were ever prosecuted. The Whiskey Rebellion was an armed uprising against the national government, and in its aftermath, only two rebels were ever convicted of treason, and President George Washington pardoned them both. Indians who attacked whites and enslaved people who resisted, however, received no such indulgences. I'd actually initially already recorded this, and like I did with the first three sections, had read those individually and responded to them individually. But it just really, by the time I got to the end of point four, it really kind of already feels like this guy is beating a dead horse. And then when we come back around to point five, it's almost as though like he stopped for a moment to check out his handiwork, came to the decision that no, that dead horse just isn't dead enough, and gave it another thrashing. So, why don't we just quickly, as quick as I can here, try and check off what he has said here that is totally untrue, and what in his argument are just complete non-starters. First, he keeps using the term during the 18th century. Now, since the Bill of Rights was ratified on December 15th of 1791, he is saying a century in which 92% predated the creation of the thing whose creation and effect we are supposed to be discussing. So, when he says throughout the 18th century, he's talking about laws that existed before the Constitution, and when the colonial government ceased to be, it's important to keep in mind that the colonial laws largely ceased to be. This is just a new way of blaming the Second Amendment for things that it could not possibly be responsible for, but that is nothing new. Uh, so notice here too how he has suddenly changed the meaning of the Second Amendment. In the other videos, we saw at first that what he said is the Second Amendment was created to create militias to prevent standing armies. Now he's saying that it was the Second Amendment was created to create militias to oppress slaves. So how a part of the Bill of Rights can oppress slaves before the Bill of Rights existed is as yet an unsolved mystery on my end. And then again in point five, we once again see his definition of the militia and his purpose change. Now, they exist as our de facto law enforcement agency, not an instrument of oppression used to solely against slaves, and not as a military force that's meant to prevent a standing army. And this goes back to points that I've made in prior videos. That it really is important in people making these sorts of arguments that they never really give a precise definition of what the militia is, because once they define it, they can no longer claim that intent is dynamic in a way that allows them to apply it to any argument in any way that suits your argument in the moment. Now, what is interesting here is that he entirely by accident uh, begins to make an argument that I actually wholly agree with. And he is saying that since our nation's founding, uh, gun control has been consistently used as a means of racial oppression. This is true. This is absolutely true. Um, there is a good argument to be made that our country's first gun control advocacy groups were not, as some people might guess, the Brady campaign or one of Michael Bloomberg's groups, the Every Town or whatever. The first gun control advocacy group in the United States was arguably the Ku Klux Klan. And that gun control and racism are inseparable to me seems obviously true. I want to turn it over to a friend of mine here, a gentleman named Maj Tour. He's the founder of a group called Black Guns Matter. And I'm going to let him explain why it is not the Second Amendment that is perpetuating racism. It is the laws that have been passed in spite of the Second Amendment, not because of it, that act as the instrument of oppression.
Peace, solutionaries. All gun control is racist. Seems like a controversial phrasing, but it's actually not. It's factual. The people that do think it's controversial are people that are unaware of the origins of gun control in America. At a certain point before emancipation, meaning black people in America that fought for their liberation. After the emancipation, there started to become rules governing people of color from having firearms. Before then, America was a completely constitutional carry country, as it should be now. The problem with people not knowing the history of that is they think that the rules as far as gun control goes are based in safety. They are not. Also, some of those people that aren't aware, that when they say, "Oh, it's 200 years ago," that was however long ago. They don't understand that most of the majority of major pieces of gun control in America were also tied into racism. Not just African Americans, but you had the natives, the first federal gun grab, Wounded Knee, massacre of natives for people to, it's gun control, people to hand their firearms over. You fast forward up into the NFA, which was enacted, in the name of those Italian mobsters with those fully automatic machine guns that are killing everybody. Point being is a lot of the legislation, or all of it, especially the major pieces, were created out of a space where there was a villainization of one racial group or an economic group or something of that nature, but primarily based on race.
All right, I gotta be honest. Part of why I wanted to put that in is just because I love the fact that he actually created a shirt that says "All gun control is racist." That's awesome. Um, the other reason too is I like turning people here in these videos onto groups that I follow, organizations that I am interested in, and that I think people who watch my videos might be interested in. So I wanted to take this opportunity to highlight Black Guns Matter, which is the group that Maj started and is the leader of. And Black Guns Matter, as you can see, educates people in urban communities in all 50 states on their Second Amendment rights and responsibilities through firearm training and education. Uh, Through support and patronage, Black Guns Matter continues informing urban communities, especially youth, about safe and legal firearm knowledge, conflict resolution, and the Second Amendment. So yeah, Black Lives Matter is just, they're a fantastic organization doing really good, important work. So I have put a link to their webpage where you can go learn more about what they do. Check down in the video description. I encourage you to, after this, go check them out and just get acquainted with what they are about. So, what we're essentially getting at here is that uh, gun control, um, as a means of racial oppression, is an abrogation of the Second Amendment, right? It is not the purpose of the Second Amendment. It's just, for some reason, I very much doubt that this would be an argument that this author would extend to a right that he doesn't wish to destroy. Uh, Painting the Second Amendment as racist, because that right has been restricted through gun control for purposes of racial oppression, now makes the Second Amendment racist. But would he be making the same argument about voting? After all, free blacks really didn't have the right to vote until the 15th Amendment was ratified on March 30th of 1870. So does the fact that free blacks and those who were in slavery lacking the right to vote for the first 80 years that we were a nation mean that our democratic process is intractably racist? I very much doubt that he or anyone really who is employed writing for the Washington Post would ever make that argument. Although, in all fairness, I can't really be certain about that. I generally try and avoid reading the Washington Post because every time I do try and read it, I end up throwing up in my mouth just a little bit. Anyway, moving on. While it while it is entirely absurd to say that because our author can identify an example of crimes that were committed by people who happen to be white and who were not brought to justice, that must mean the disposition of the entire colonial society as a whole was one where people were willing to be victims of violence as long as those attacking, robbing, and killing them were white. The purpose of the Second Amendment is to make sure that we are victims of no one. So, this author even admits, really, that these acts, such as what he talked about with the Paxton Boys, that these were widely denounced by prominent members of society, and that arrest warrants were issued for the crimes committed. Uh, that the perpetrators, who lived in what was a geographically vast country made up of 13 different colonies with 13 separate legal jurisdictions, as well as living on a vast frontier that was not subject to any jurisdiction at all, seems to me just about the most advantageous circumstances one could possibly hope for to run from the law successfully. Now, the two examples he gives in which people were brought to justice is illustrative how our author is either voluntarily ignorant of the circumstances to which he is speaking, or he is intentionally lying to flesh out what is really a much weaker case than he wants you to think he has. Shays Rebellion and the Whiskey Rebellion, uh, both of which occurred before the ratification of the Bill of Rights. Now, Shays Rebellion uh, saw nine of the rebellion's ringleaders, including the one for whom it got its name, Daniel Shays, uh, hanged for their crimes. Until Shays' rebellion, as a matter of fact, we were really barely a nation. It was at that point we were still 13 sovereign states in a very weak and informal confederation under the Articles of Confederation. And as a matter of fact, until Shays' rebellion, there were really only a handful of leaders throughout the country. Just a few people like James Madison, Alexander Hamilton, James Wilson, Gouverneur Morris, really just a fairly small handful of people who had been pushing for some time for the need to strengthen ties and to centralize some power, or we risk descending into anarchy and could have very easily been overrun and repatriated by Great Britain or have had territory annexed by France or Spain, who would have been thrilled to take advantage of that opportunity had it been given to them. But the vast majority of our citizens in all 13 states and in the state governments especially uh, had a strong distrust of other states. And really, you find that the further away two states were geographically, the less they trusted each other. And so no state government, as they existed under the Articles of Confederation, had been willing to give up any of the power that they held under the Articles and their state constitutions as sovereign states. That is, of course, until Shays' Rebellion. It was precisely the actions of this group of uh, basically a band of armed, war vets and yeomen that convinced the state governments to set their trepidations of losing power aside and to agree to taking part in the Philadelphia Convention of 1787 that was what eventually gave us the Constitution that replaced the Articles of Confederation that gave us the stronger government that we have today. And with the Whiskey Rebellion, we have another case of what kind of seems like either unintentional ignorance or maybe intentional deception. I can't really be sure. Um, but the fact is that really only in the strictest sense could you refer to the Whiskey Rebellion as an armed uprising, because that fails to convey the fact that, unlike Shays' Rebellion, the Whiskey Rebellion did not commit one violent act against any person or property at all. That when George Washington personally rode out with militia and confronted these rebels, they all laid their arms down immediately and without resistance. and this rebellion started and ended without a single shot being fired by parties on either side. So I to refer to it as a armed and giving the impression of violent rebellion is just to uh yeah. Um anyways, with the major that really clears up the major inconsistencies in these last two sections. So it's time to get on to what I think is going to be the most, certainly the most interesting part of this video, and arguably the most interesting part of any of the three videos in this series. Uh, this is the part where he accidentally makes one of the best arguments in favor of an original meaning or a textualist understanding of the Second Amendment as an individual right. So he says, see, yeah, during the 18th century, uh, insurrectionary groups and vigilantes showed the government that they could not simply issue laws and expect people to obey them. Uh, this is precisely why so many of the states, in their individual state constitutions, as well as many of the suggested amendments that were given at the time of ratification, that were submitted for the promised Bill of Rights, had wording in them that specifically talked about the right to keep and carry arms uh, as an individual right in defense of themselves and the state. It was a right of the people in defense of themselves and the state. So you cannot uh, reasonably expect a government to be there and to be ready to defend you every time marauders or criminals threaten your life, your liberty, or your property. The people needed arms to protect themselves when the government could not. And this is something that we saw going back, for example, to some of the state constitutions. So, yeah, here, if we go back to the Vermont State Constitution, crafted in 1793, we see that they say that the people have a right to bear arms for the defense of themselves and the state. Same thing with Pennsylvania. The right of the citizens to bear arms in defense of themselves and the state shall not be questioned. And then, as far as the ratification documents and the suggested amendments, I think a great example of what we're talking about is the Pennsylvania suggestion of what uh, the right to bear arms should have said in the Constitution. And as they put it, that the people have a right to bear arms for defense of themselves and their state, or the United States, or for the purpose of killing games, and that no law shall be passed disarming the people or any of them unless for crimes committed. So I think for today, we will stick with what the Second Amendment can be said to uh, expressly protect, and that is the right of the people to keep and bear arms as a defense against government tyranny. Bear in mind, Shays' Rebellion and the Whiskey Rebellion both occurred before the Second Amendment and the Bill of Rights were drafted and ratified. The reason this is important because the fact that these happened before the Bill of Rights came around meant that the founders had ample opportunity to look at these situations and decide that it's more important for the government to protect itself from the people and not the other way around. But they didn't do that. They didn't do that because experience had taught them that when a group of citizens face off with arms against their government, sometimes the citizens are in the right. Now, he actually distills this precise purpose and value of the Founders' Second Amendment without really intending to. Here we go. He says when disagreements over political issues turned violent, the government would not necessarily enjoy the balance of power over citizens who, as militia members, were trained and armed. And that's it right there. He just described the founders' Second Amendment. Perfectly, perfectly described it. Now, just to be clear, uh, this is not at all about using arms or violence as a legitimate tool to resist a government who is following the law and the Constitution. That is to say, if we can go back to sort of Randy Barnett's phrasing of what the Constitution is, that the Constitution is the law that governs those who govern us. So when the actions of our government are in accord with the laws that are meant to govern those who govern us, uh, they may take actions and pass laws that we do not agree with. That doesn't automatically make them unconstitutional. Uh, and when dealing with laws we don't like, we certainly have a First Amendment which protects a number of means for us to peacefully seek that change from our government, which should, of course, always be the first recourse. However, the point of the Second Amendment is because when push came to shove, the Second Amendment was there to make sure that it was the people and not the government who were the ones doing the pushing and the shoving. It is a means to fulfill the ideal spoken of in the Declaration of Independence when they wrote, governments are instituted among men, deriving their just power from the consent of the governed. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it. Prudence indeed dictates that governments long established should not be changed for light and transient causes, and accordingly, all experience have shown men are more disposed to suffer while the evils are sufferable. But when a long train of abuses and usurpations designed to reduce them under absolute despotism, it is their right, it is their duty to throw off such government. The Second Amendment is the means that gives teeth to the very concept of a belief in government of consent. And this actually goes back to a couple sources I've used in past videos I wanted to revisit here real quick. Here we go. So, first of all, we have Alexander Hamilton, as he said in Federalist 28, if the representatives of the people betray their constituents, then there is no recourse left but in the exertion of that original right of self defense, which is paramount to all positive forms of government. We also have Tench Cox talking about Congress have no power to disarm the people, their swords, and every other terrible implement of the soldier are the birthright of an American. The unlimited power of the sword is not in the hands of either the federal or state government, but, where I trust in God it will ever remain, in the hands of the people. He also goes on to say that whereas civil rulers, not having their duty to the people before them, may attempt to tyrannize, and as the military forces which must occasionally be raised to defend our country might pervert their powers to the injury of their fellow citizens, the people are confirmed by the article in their right to keep and bear our private arms. We can also turn to Noah Webster, Citizens of America, where he says, the supreme power in America cannot enforce unjust laws by the sword, because the whole body of the people are armed and constitute a force superior to any band of regular troops that can be, on any pretense, raised by the United States. This is also this exact thing is discussed by James Madison in Federalist 46, which I'm not going to read because it's like 6 pages long, but You should go check it out and give it a reread if you're not familiar with what I'm talking about. Federalist 46. I mean, he breaks this argument down in like a surgical, scientific way. It's really beautiful. So, all of this here, though, to kind of start wrapping up, uh, underscores part of why I consider myself a textualist. So, first of all, let's find a good definition of textualism. I think a very good definition is one that comes from a Justice Bullock. He is on the Arizona Supreme Court, and he says textualism is grounded in the belief that the role of judges is to enforce the Constitution and laws that conform to the Constitution. A textualist endeavors to give effect to the words of the Constitution and statutes. If the meaning of the words are clear, the judge goes no further. If they are ambiguous, the judge will attempt to discern their meaning using well developed rules of construction. And this is kind of summed up in the phrase a verbis legis non est recidendum, which means from the words of the law, there is not any departure. So, here is where I think the difference between something like original meaning, such as have been sort of talking about in the past in the other videos, and textualism, where original meaning is slightly weak, and I think textualism makes a stronger case. Um, I have a clip here that comes from the was it the confirmation of Justice Gorsuch recently, and he is being asked questions by Senator Dianne Not So Feinstein, who is asking him about how Scalia interpreted original meaning in the 14th Amendment Equal Protection Clause. Uh, and Justice Gorsuch explains his own definition of this clause as a textualist. So, if we substitute the idea of equal protection under the law with the 2A clause, the right of the people to keep and bear arms shall not be infringed, I think can illuminate the difference between original meaning and textualism in the Second Amendment. So,
Do you agree with Justice Scalia's statements that originalism means there is no protection for women or gays and lesbians under the Equal Protection Law because this was not the intent or understanding of those who drafted the 14th Amendment in 1868?
And so when it comes to equal protection of the laws, for example, it matters not a whit that some of the drafters of the 14th Amendment were racists, because they were, or sexist, because they were. The law they drafted promises equal protection of the laws to all persons.
so what I would say is that when it comes to the Second Amendment, it makes absolutely no difference if some of the people who wrote the Second Amendment were racist, and they were. The right of the people denotes a natural right belonging to every single person, and shall not be infringed means that the government cannot pick and choose how a person chooses to defend themselves. You can't pretend the right to keep and bear arms excludes certain type of scary looking firearms. You have no authority to grant the ability to let people buy a firearm with a 10-round magazine, but claim that an 11-round magazine is superfluous. Shall not be infringed in a textualist reading is an absolutely clear and unambiguous statement. So look, it is a sad fact that when we put down this charter of universal declarations, of individual liberty that we have through the Declaration of Independence and through to the Constitution and the Bill of Rights, that we put some of these protections in place before we truly started living up to them as a nation. But to kind of go back to something I said earlier, does the exclusion of black men from voting for the first 50 years of our country and the exclusion of women for nearly the first 100 years of our country from voting uh, mean that voting is not a right? Uh, and does it mean that the democratic process is fundamentally without value, that it is, uh, it must be obsolete because it is too tainted by racism and sexism? Or is it still something worth cherishing? I would argue it is. Uh, and so, even those who write off the Second Amendment as somehow being exclusionary, I truly do not think would be willing to extend their claims to constitutional protections that they value, such as something like the right to vote. I can't imagine any journalist would be very quick to dismiss the First Amendment's protection of a free press needs to be discarded because of the private character flaws of the people who drafted and ratified the First Amendment. So, the recognition of our natural rights to self defense and, by extension, our constitutionally protected individual rights to keep and bear arms have not always been recognized equally in all individuals. No one would argue that it is fair or moral to have excluded anyone from that equal protection and enjoyment of the right in the past. But no partial exclusion that existed in the past to the full protection of liberty makes it fair or moral to fully exclude everyone from the protection of liberty in the present. I understand that from its founding, we have often fallen short to living up to that vision of equal liberty for all people. But that doesn't make it a bad idea, and it certainly doesn't mean that the better solution is to give up our natural rights and exist in perfect and equal tyranny. I prefer perfect and equal liberty for all. I don't know if that's possible, but I think it's worth continuing to strive towards. And in the meantime, as for me, I will take imperfect liberty over perfect tyranny every time. All right, well, that is going to do it for today. I will be back with a new video in a few days. So if you like the show here and you want to take a moment and give it a thumbs up, uh, smash that like button. If you aren't subscribed to the channel, maybe consider subscribing to the channel so you can be informed when new content goes up. And what I ask people to do is if you liked this episode, I I would ask that you just take a minute and share it with one person who you think might also enjoy hearing it. And feel free to leave questions or comments, praises or abuse in the comment section. So until next time, this has been Categorical Imperatives. I have been Lockean Liberal. Uh, we have been talking about the Founders' Second Amendment. And as always, Delenda est Carthago.